So that being said, what public bodies can do is where it's, there's a really large amount of records, and quite often you do see this, where you'll get, I'm going to go back to the flood example, where people want all of the flood records. The public body does have a right to charge for that. But you'll be sad to learn, and well, maybe not as ratepayers, you won't be sad. Council will be sad to learn it's actually not a lot of money. And so it doesn't recoup your staff time. But that being said, the basis for FOIP is not about a cost recovery model. It is about providing openness and transparency to residents and ratepayers. So what the public body does have a responsibility to do in those really extenuating circumstances where they know it's going to be over $150, which is quite a high, you have to have quite a lot of records to meet that. It's something like $6, for every quarter hour. Like it's really, really minimal what you can charge, and you can only charge for certain things. And those things are set out actually in the regulations. So basically what happens is if you know you're going to meet that over $150 threshold, the public body has a duty then to prepare a fee estimate and send it out to the applicant. So they send it out and say, this is what we think it's going to cost to fulfill your request. What they can charge for is searching, locating, and retrieving a record. They can charge for the cost of computer processing, which generally and nowadays is quite minimal. Time and cost for computer programming, if that needs to be done to configure the information. And they can charge for a cost to produce a copy of the record, as well as the time and cost for preparing and handling the record for disclosure. When I say preparing and handling the record for disclosure, I do not mean I had to review 400 documents. I'm saying if I had to review this piece of paper and redact information, I can only charge for the amount of time it took me to redact that information. So it really becomes very, very, like I said, very small amount. The time and cost to supervise applicants who want to examine records is also something that can be charged for. So quite often you get people that want to come in and maybe they want to look at some of the drawings or things that you have in-house. They don't necessarily want to pay for those things. They want to come in and just see them. You can charge for that. But again, provided it's above that $150 threshold, as well as the cost for shipping records to applicants. Once you have the fee estimate drawn up and you send it to an applicant, the applicant has 20 days to respond. So they can accept the fee estimate, they can pay 50%, and thereby you move forward with processing the request, or they can modify their request at that time. So quite often what I see is you send these fee estimates out and people think, oh, I had no idea it was going to cost that much money to get. That's not really what I'm looking for. I just want this one agreement. And then that helps to sort of scale it back both for the public body and also make it easier for the applicant to get the information that they're really looking for. Yeah, go ahead.
So are these fees, you said they're in the regulations?
Yes.
And so there's an itemized list
Yes.
of things. And are these updated annually? Is there a clause in the regulation about periodic updates to the amount of fees? Or?
There's nothing in the regulation about how often they're updated. But it does specify you cannot charge above those set fees, right? So if it says it's $6.25 an hour or $6.25 every quarter hour, that is the maximum you can charge.
And in your experience, what would a typical request be? I know I'm asking you to typify something that probably is a huge spectrum.
Typically, yeah. I have only had to do 1 or 2 fee estimates ever. Because, like I said, it's a very high threshold to meet. And having, in my experience, when I came into this role, I actually had to defend a claim that had gone to the Office of the Information and Privacy Commissioner. And that's when it was made very clear that you cannot charge for, like I said, reviewing documents. So even though you want to review for relevance, those are things you can't charge for, which the public body had been previously. So that's where run into issues. But the Office of the Information and Privacy Commissioner publishes their orders online, and so you can actually see any of the decisions that they've made, and typically they do follow their own past precedent with regards to their decisions. Did that answer your question?
Yes.
Okay, perfect. Okay, yeah, and so like I said, you have 20 days to accept the fee estimate, and then continue with the processing after either the fee is paid or after the request has been modified to come under that $150 threshold. So, individuals who cannot afford to pay either the initial fee or perhaps any fee above that $150 fee can actually apply to the public body for a fee waiver. So they can write to the head of the public body and say, you know, I can't afford this, or perhaps we've requested this information. It's actually in the public interest that it be released for free. With regards to the public interest, it's very specific in terms of what that means. So environment, public health, and safety. This was another issue that I had to defend on that same matter, was because it was in relation to the flood claims. This particular individual thought it was in the public interest to release all of the flood information. And honestly, I don't have any problem with that. However, the legislation doesn't provide that as being, the flood had already passed. It wasn't an emergency when this information was requested, so it didn't meet that criteria. Once the public body has determined whether or not a fee waiver will be granted, they have 30 days to notify the applicant of when they've received that request for a fee waiver. And then the applicant, again, can decide to proceed. They can decide to appeal to the Office of the Information and Privacy Commissioner if they don't think that it's been fairly handled, all of these sorts of things. So now I want to move into the exceptions. And so there's mandatory and discretionary. So mandatory are ones that the public body must withhold the information. So the legislation is very clear. It says you must do these things. If you meet this criteria, you cannot release the information. Discretionary exemptions talk about where the public body may withhold information. So really then it's up to the head of the public body to make the decision about whether there would be harm caused in releasing the information. One of the things that's I would really caution probably more council and administration about is to use those discretionary ones sparingly. Don't, just because you can doesn't mean you should. If there is harm, then by all means you definitely should be withholding that information.
Is that harm to the general public or harm
So
to the
the act actually is very specific about how harm is defined on each of these things. So it talks about, we're going to move into personal information, and it talks about when is it an unreasonable invasion of privacy, right? And so, for instance, the act says if you put your name and your address together and release that, that's an unreasonable invasion of your privacy. However, if we just release your address, it's not, right? So there's certain areas, and it's very specific. I'm not going to get that detailed in here about that, but I can certainly answer any questions that you have. So these are the two main mandatory ones. So the disclosure harmful to business interests of the third party, and then disclosure, again, as I mentioned, the unreasonable invasion of personal privacy. So harmful to business interests of a third party is things such as trade secrets, commercial, financial, labor relations, scientific, or technical information that has been supplied explicitly or implicitly in confidence to the public body. So if you take, for example, when you go out for do a tender or an RFP, you're going to get a lot of information back as part of that process. Some of that may be very technical in nature. It may have unit factors in terms of how pricing is established and all these sorts of things that would jeopardize that company's ability to compete with other companies if that piece of information was released. That being said, if you are releasing or redacting that information, you redact just that piece of information. The rest of it gets released. But this goes through, you have to work with those people, right? So the public body doesn't have the authority nor the skill to be making those decisions independently without consultation with the affected business owner or person. So that would be something I would really...
So if we were speaking of that example, if we were determining how much concrete we're going to pour, and that was my business's specific information.
Right.
But the total cost of the
That's absolutely right. So those are public dollars.
How we determine what we're gonna charge, but we would actually get to see what was charged.
Yes, absolutely. So you could see what was charged. Anything except that, probably that unit factor, would all be released, including the amount. Because those are public dollars, that does, the Act doesn't allow you to protect that information. And so, like I said, the disclosure has to harm the competitive position or interfere significantly with the negotiating position of the third party. So let's say that you release that information. It may prejudice their ability to compete with other businesses or negotiate for other contracts or these sorts of things. It may also result in these third parties no longer providing that information to the public body, which is not in the public body's interest in terms of awarding contracts. You need to have a certain level of information shared with you. It can also result in a financial loss or a gain, even to any person or organization. That is considered to be harmful for obvious reasons. It can reveal information supplied to or any report of an arbitrator, mediator, labor relations officer, or person or public or body appointed to resolve or inquire into a labor relations dispute. That is also considered to be harmful. A public body should refuse to disclose information about a third party that was collected on a tax return or collected for the purpose of determining a tax liability. So let's say you send out, I'm going to use Leanna as an example here, send out a survey to all of your business owners and you're asking for very specific information about their business. If that was collected just for the purposes of generating an assessment and all of these things, that should be protected.